Hello. Hey, Miss Whitney.
Hey, how are you?
I'm fine. Deputy Mayor with the Sheriff's Office.
Yes,
So I'm here because of, well, obviously I'm pretty sure you know why I'm here.
Just another friendly hello between a deputy and a store employee. What neither voice reveals yet is that months into this investigation, some of the missing cash was still sitting only a few feet away.
I still have a little bit of money.
You still have a little, where is that at? Over at the house?
Actually, yes it is.
It is at the house, or it's not here with you anywhere, like in your car or whatever?
Not here.
Yes, ma'am.
Is this chaos?
Where is she at?
She's in the office. She asked me to tell you you're coming. I stepped out to call you guys. She's already admitted to, it's $4,900. It's right sitting under
Okay.
$5,000 worth of theft
Okay.
of money. She's admitted to it. We already have a statement.
Do you already have her statement?
We already have a wet statement and a reimbursement form and everything. We get all that before we call you guys.
Okay. So, have y'all reported the money missing in the past?
No, we did. That's what we're doing today. We came to investigate it. We found it today. She submitted to it, so that's what this policy is to call you guys today of.
And y'all are missing that much money?
Yes, she's already confirmed it. We have it. She took
She confirmed it.
Yes. She
Well, I'm asking did someone confirm the deposits
yes,
were actually?
my loss prevention's in the office.
Okay, that's
So
why
the guy- yes, the guy
that's why I was making sure. I was like,
I'm the district manager, so that's what we're doing today.
Okay.
We get all the investigation, do all the hard work before you guys get here.
okay,
So she's already wrapped up in a bow.
okay. Let me go ahead and call my sergeant real quick, and then I'll just I'll meet you back. Oh,
Well, it's in the front. I was just walking around, so she didn't know because they're in the office.
okay. Hello. Hey, Miss Whitney.
Hey, how are you?
I'm fine. Deputy Mayor with the Sheriff's Office.
Yes,
So I'm here because of, well, obviously I'm pretty sure you know why I'm here. Okay. So do you need to talk to her anymore? Are y'all done? I can talk to her now and okay. All right. Well, I'm gonna read you a couple things. I'm gonna read you something real quick, okay? All right, because right now I'm starting my investigation, okay, based off of what they've told me and what you've told them and stuff like that. I don't want to start asking you a bunch of questions and you not know your rights, okay? So Miss Whitney, you have the right to remain silent, okay? Anything you say can and will be used against you in the court of law, okay? You have the right to talk to a lawyer and have him or her present with you while you're being questioned.
Oh my God.
If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand that each of these rights I've explained to you?
Yes.
Okay. And I know you've talked to them, but obviously I gotta ask a couple questions, probably some of the same questions they've asked. Do you want to, knowing your rights, do you want to talk to me too?
So.
I'm sorry, I can't hear you.
I would assume so.
So that's a yes?
Yes.
Okay, here. What I'm gonna do. Can you spin the chair? That way I can see your face. I'm sorry. Maybe like put it up against that. There we go. All right, Miss Whitney. So tell me what's going on. Why am I here? You made a bad choice. Okay. What choice was that?
Instead of looking for help, I tried to go through the store.
You tried to get your own help. Is that what you were saying? So tell me how you did that. Tell me what happened.
Pretty much I had a situation and I had a bill that had to be paid. So I took some money.
Okay.
I've been trying to pay it back little bit by little bit, but I didn't know.
What? You mind what I asked? What bill?
I had some medical bills.
Some medical bills and stuff.
Yes, and just everything on top of the house bills that I had really fell on some hard times and I didn't know what else.
Yeah. Okay. When did you first take money
Honestly,
that you can remember?
it's been a minute. I think that's why it's been taking so long.
Okay. Have you taken it over time, or just like one one deposit, or like how did that work?
It was like, how probably like once or twice. So now here I am trying to put the deposits back like they go.
Mm-hmm.
And
so let me ask you this: how much did you take in total that you remember?
He's saying there's 4,968.50.
Does that sound about correct as far as like how much you took?
I mean, it would have to be.
Yeah, because you took that much. Okay. Was it like you said once or twice?
I mean, for me to just have you know what I'm saying?
Yeah, 2 deposits. Yeah, I know
Right.
sometimes the store makes you drop it after so much. Yeah, I get that. I used to run Subway a long time ago, so I know how the deposits and stuff work, like daily or hourly or whatever. Okay, so you say, when was the first time you took it? Just give me an estimate. If you can't remember a specific day, I mean, just...
I probably wouldn't really, but I started getting sick a couple of months ago, so...
So it was probably within a couple months until...
Yeah.
When was the last time you took it? Do you remember?
It hasn't been. I've just been trying to
okay.
fix you know what I mean?
So it was like a one-time thing where you took maybe like 2 deposits and then...
I'm just
trying to feed it back in or whatever? Okay. Okay, so... How did you do it, if you don't mind my asking? How did you take the money as far as...
I mean, really, I just took it out the store.
Okay. Are you like a key holder or something like that where you have access to the deposit?
Yes, sir.
So you took the money, you took it out of the store, and then obviously you took it with you or whatever. Okay.
But pretty much all I've been doing now is just trying to balance the deposits out until I got the money back paid. You know what I'm saying?
Okay.
And apparently, it caught up with me.
So they caught it and they... Okay. Alrighty. Okay. Have you ever done anything like this before?
I have not.
You have not?
I was raised like I'm a good woman. I really felt in some bad times that I made the worst fucking decision of my life. And if I would have known I'd be where I was, I swear to God, I would have done that shit. Like, I have kids and stuff.
Yeah, man. Okay. Do you have your ID on you anywhere, or?
No, sir. Everything is at home.
Okay. So I'll just go ahead and get your name and date of birth and stuff like that real quick. What's your first name? I know have you filled any sort of form out with them? Okay. Alright, do you wanna fill out a form, like fill out one of my forms also, just kind of telling me what you did, or?
I mean, if it's gonna be the same as what they have, I mean.
Well, so that right there is, I'm not sure what kind of form they have. Mine is a sworn statement. Okay, so mine is you're telling me, obviously I got this on body camera, but then we put it in writing, and then I swear you to what you're telling me is true. Okay, so that is completely up to you. You don't have to do it if you don't want to. I can't make you. If you want to, you can always just swear to the statement that you've made verbally, and you don't have to write it all out if you don't want to. So that's all up to you.
Okay.
So, would you want to...
I'll swear to the statement.
Verbally? Okay, just go ahead and raise your right hand for me. Okay. Do you swear and affirm that the verbal statement you gave me is true and correct, best of your knowledge and belief? Okay.
In a Dollar General store in the Florida Panhandle, an internal audit had already built most of this case before any deputy arrived. $4,900. That is the number sitting at the center of this prosecution. Under Florida law, that single figure decides whether this is a felony or a misdemeanor.
Just to ask real quick, what was how are you putting it back? How are you trying to put it back in there, like balance it out? Were you just trying to feed some of your own money in every now and again?
Yeah.
Okay. Do you know how much you might have paid back by the time?
Not as of right now, no.
Okay. All right.
Like I was still in the process of paying it back. Okay. It's nothing I would have done.
Okay. And I heard that you might still have some of the money, or is that just your money that you're trying to pay back?
No, I still have a little bit of the money.
You still have a little. Where is that at? Over at the house?
Actually, Yes, it is.
It is at the house, or it's not here with you anywhere, like in your car or whatever?
Florida Statute Section 812.014 does not create a separate embezzlement crime for employees. Instead, taking an employer's cash falls under the same general theft statute as any other theft. The statute sets clear dollar thresholds that decide how serious the charge becomes. Property valued under $750 is petite theft, a misdemeanor. Property valued at $750 or more, but under $20,000, is third-degree grand theft, a felony. The deputy in this case pins the loss at close to $4,900, squarely inside that felony range. That number is not incidental. It is the entire reason this interaction ends in handcuffs instead of a citation. She describes taking the money on more than one occasion over a period of months. Florida law allows multiple separate takings to be aggregated into a single grand theft charge when they are part of one continuing scheme. That aggregation is exactly why several smaller withdrawals add up to one third-degree felony, rather than several minor misdemeanors. Her role as a key holder with direct access to the safe does not create a separate criminal charge under Florida law. Unlike some states, Florida has no distinct fiduciary or embezzlement statute that increases penalties based on a position of trust. That access is legally relevant only to how the case was built, not to how the crime itself is defined. Before any deputy walked into that office, Dollar General's own loss prevention team had already obtained a signed, sworn statement. That detail matters constitutionally more than it might seem. The Fifth Amendment's protection against self-incrimination and the Miranda warning that enforces it restrict government actors, not private employers. A loss prevention investigator questioning an employee is not required to read Miranda rights because no state action is involved. So the confession obtained by the store on its own was never at risk of Miranda suppression. The deputy's own interview is a different matter entirely. Once law enforcement takes over, the Fifth Amendment applies in full force. And here the deputy makes a deliberate choice. He reads Miranda rights before asking a single substantive question. On camera he says, quote, "You have the right to remain silent. Anything you say can and will be used against you in a court of law." End quote. At that exact moment, the subject is seated unrestrained in a private office, not yet formally arrested. Under Miranda v. Arizona, 1966, warnings are only constitutionally required once a person is in custodial interrogation. That means both restraint, comparable to arrest, and active police questioning have to be present at the same time. A strict reading suggests the deputy may not have been legally obligated to warn her at that exact point. But giving the warning early is a common defensible practice once an encounter is clearly heading toward arrest. It closes off any later argument that her statements to police should be thrown out. In other words, the deputy over-complied with Miranda, and that caution worked entirely in the prosecution's favor.
At the house in a bag, or it could be in my van. I have to.
In your van? Is your van here?
It is.
Okay. Would you give me consent to look for it? That way I can find it.
Yeah.
Okay. All right. We'll do that here in a moment. It's too hot for me to go outside and sit there and come back for this, that, whatever. Okay. So we'll get this done here first, and then you have your keys on you. Is that your purse, or is that something?
So that's my keys are actually
Are they in your van still?
probably up front.
Oh, up front? Okay. You left your stuff up front. Were you coming into work today?
Yes, sir, I was.
Oh, okay. Alrighty. Okay, Miss Moore, just kind of sit tight for me real quick, and then I'll kind of explain the next couple steps for you, okay? Ma'am? So, obviously, her van's going to be here whenever she leaves. Are y'all wanting to tow it, or y'all allow her to have someone come pick it up? Okay. Yeah, I just want to make sure. Do it? Yeah. Okay. Yeah, I'll let her know.
Yeah, Mom, I know.
I'm
so sorry, Mama.
Miss Whitney, how do you want your van taken care of?
My mom can
come get it? Okay, now we're going to have to leave the keys up here with someone.
That's fine.
Okay, do you trust them to hold on to the keys until Mom gets here, or do you want one of us to hold on to the keys until...
I trust them up here.
Okay. Okay, I just want to make sure. I didn't want to leave your van here because they sound like they're going to let it sit until someone comes to get it or whatever, okay?
I guess they taking me to Walton County.
It'll be Walton County, yes, ma'am.
Mama, I don't know. I don't even know if I'll get a bond today.
I don't think so. Not today, anyway, because of the amount. But you can... don't quote me on that because I'm not a booking specialist. The booking specialists up there, whatever you're getting charged with, as far as the statute goes, they have a worksheet that tells them if it's a first appearance or if it's going to be... But I believe it's a first appearance charge.
So
Okay.
I have to go to court first.
Well, it's not court. It's you see a judge in the morning, and then he gives you a bond.
Okay. So more than likely, I'm gonna have to sit tonight until in the morning. It's like 4,000 and something. Mama, please, I'm already stressed out. I'm so sorry, Mama.
Did you let her know to go watch your kids and all that?
Just please go and the kids, my purse is at the house. That card, that EBT card is in there. Just go ahead. Like, Reggie gonna have to know. They finna get ready to take me.
Yeah, because we gotta get this going. That way we're not sitting here, okay?
I'm so sorry, Mama. I'm so sorry.
Tell Mama you call her back, okay?
I'm gonna leave my phone and stuff here and just tell Daddy to stay by his phone. His number is the only one I can remember. Okay?
Well, you can take your phone if you want.
Okay, they said I can take my phone.
You can take your phone. The phone, they'll allow you to get phone numbers off of it if you need it.
Okay.
Okay?
All right, well, I'm going to take my phone with me, Mama, okay? Just tell my kids I'm so sorry.
Okay.
Mama, I know, but it's done now. Okay, let me go so we can get this process over. I'm so sorry, Mama. I gotta go.
Okay. Do you have anything else on you other than...
No, not that I could think of. But they will let me get my phone.
Yeah, as long as you're cool with them, they'll allow you to go into your phone and only your contacts to get a number, and that's it. No texting, no doing any of this, because once you do that, then they got to act on that, okay? Because they can't allow you to do anything else, okay? And you don't have anything else on you, no pockets or nothing like that, okay? All right, well, I got my sergeant here, so you won't help me with that, okay? So, just go ahead and turn around. Hands behind your back for me, okay? So, at this time, you're being placed under arrest for grand theft, okay? Don't try and put them on too tight. You got small wrists and small hands, but hey, do me a favor. Can you turn your wrist like okay, turn this one this way? Yeah, like a prayer, okay? That'll help you. It'll be a little bit more comfortable for you, okay? All right. It's not too tight or anything, is it? Okay, I gotta tighten this one up a little bit. Like I said, you got small wrists, so I don't want... Okay. Grab this stuff here. You almost done getting that stuff loaded up onto the thumb drive? Okay. This has all the amounts and the video and all that?
That's the video, yeah, and it has, you'll see my worksheet.
The worksheet on that? Okay.
To the side of what's missing and all that.
Alright, thank you very much.
Just need to
She's got it actually on her, on the victim right brochure I gave her. You're good. It doesn't hurt. Alright.
The second constitutional question in this footage is the search of her van. Midway through the interview, the subject admits some of the missing cash may still be at her house or in her vehicle. The deputy does not attempt to seize the van and does not seek a warrant. He simply asks a direct question. Quote, "Would you give me consent to look for it?" End quote. She answers yes. Under Schneckloth versus Bustamonte, 1973, a consent search is valid if it is voluntary, based on the totality of the circumstances. Critically, the Supreme Court held that officers are not required to tell someone they have the right to refuse. So the absence of any warning about her right to refuse does not by itself undermine the legality of that search. Nothing in the footage suggests threats, promises, or coercion attached to that request. On these facts, the consent appears to meet the constitutional standard. There is a related question worth raising. Was any part of her statement to police involuntary in the constitutional sense? Under Colorado versus Connolly, 1986, a confession is only involuntary under the Fifth Amendment if police coercion produced it. Emotional or financial pressure that exists independent of police conduct does not make a statement involuntary as a matter of law. Whatever pressure she felt from her employer or from her own financial situation does not translate into a constitutional violation by the deputy. Her statement to police, given after a clear warning and without threats on camera, stands on solid constitutional ground. One more legal nuance deserves attention. Florida's theft statute does not require an intent to keep property forever. The statute covers depriving an owner of property, quote, either temporarily or permanently, end quote. That detail directly undercuts her own account. On camera, she says, quote, "I've been trying to pay it back little bit by little bit," end quote. Under most people's intuition, intending to repay money might sound like it cancels out the theft. Under Florida Statute 812.014, it does not. A temporary unauthorized taking, even one, paired with a genuine intention to return the funds, still satisfies the statutory definition of theft. That single legal fact is why her explanation, however sympathetic, was never going to function as a defense. The eventual sentence, 4 years of probation instead of prison, also has a legal explanation, not just a sympathetic one. Florida sentencing relies on a point-based score sheet under the Criminal Punishment Code. A third-degree felony, a clean prior record, and full cooperation typically produce a low score, well under the threshold that mandates a prison sentence. Probation is not leniency granted out of sympathy. It is often the score sheet's default outcome for exactly this kind of case. That brings the analysis to how each party in this footage should be graded. The deputy earns a grade of A-. He gave an unnecessary but protective Miranda warning, requested consent for the van search instead of assuming authority, and conducted the interview without a hint of coercion. The only mark against him is a small one he never explicitly confirmed on camera, that her earlier statement to the store was free of any promise of leniency. That gap is minor, because Miranda's protections do not reach private employers in the first place. Whitney Moore, the subject, earns a grade of C+. Her full cooperation, her waiver of rights, and her consent to the search likely worked in her favor at sentencing. But none of that changes the underlying elements of the crime she admitted to on camera. A third party belongs in this grading as well. Dollar General's own loss prevention and district management team. They earn a grade of B+. Their internal audit correctly identified the shortage, and they obtained a sworn statement before ever involving police, which strengthened the criminal case considerably. The one limitation is procedural, not legal, because they are private investigators. Any pressure they applied during their own interview falls outside Miranda analysis entirely. So here is the real question this case raises. If a private investigation can extract a full confession before police ever ask a single question, how much protection does Miranda actually provide in a workplace theft case? 3 takeaways from this case. 1. If your employer's investigators want to question you about missing money, remember that Miranda does not apply to them, and anything you say can still end up in a criminal case. 2. Intending to pay stolen money back does not erase criminal liability, because Florida's theft statute covers temporary takings just as much as permanent ones. 3. Consenting to a search without being told you can refuse is still legally valid consent. So understand that right before you agree to anything.